email address in the chat box. So I will go ahead and introduce our delightful presenter today, Emily Young. She is with Perez Law. And so Emily Young was born and raised in Huntsville, Alabama. I think you're that unicorn we always hear about, right? Nobody's actually from Huntsville.
Yeah. Yeah.
But she is an alumnus of Grissom High School and Auburn University. She graduated cum laude. I don't know. I've never done it, so I don't know how to pronounce it.
Your guess is good as mine.
Okay. From the Birmingham School of Law. And she graduated with her Master of Laws in Estate Planning and Elder Law from Western New England University. She's a councilwoman for the Elder Law section of Alabama State Bar, a member of the National Academy of Elder Law Attorneys, and the Elder Law professor at the Birmingham School of Law. And she also serves on the boards of the Madison County Volunteer Lawyers and Parkinson's Dynamics. So we do some work with Parkinson's Dynamics, lovely people.
Great.
Her primary practice area includes elder law, but also comprehensive estate and special needs planning and estate administration. And so I was very delighted to meet Miss Young the other week, and I snatched her up, worked my little voodoo on her, and I coaxed her in here so she can come and talk with you all about special needs planning. And I discussed this with Emily earlier. If you have a question during the presentation, I will be monitoring the chat. So if you have a question about clarification or what have you, just put it into the chat box and I will bring it to Emily's attention. And then after the information, if you have more personal or specific questions that you would like to ask, there will be time afterwards for that. And that part will not be recorded and put on the internet. So don't feel like, we're going to put all your business out on Front Street because we're not going to do that. And so without further ado, yes, you ready? I'll go ahead and turn it over to Emily. Thank you so much.
Oh, you're welcome. Hey guys, good morning. So I'll tell you what, that written spiel about me sounds way cooler than I actually am. But in all seriousness, I love being here today, and education is one of my most favorite things to do. Don't tell my boss that, but it really is. It's one of my most favorite things to do. And so I just was really honored to be asked to be with you and spend time with you today. So thanks for spending time with me. So I guess what we'll do is I'm going to try to go maybe about 30 to 35 minutes, somewhere in there. And Jenny, if we start going, a little too long, let me know, because what I'd like to do is save some time at the end for questions. Of course, this is not just about me talking at you. It's about everyone coming away with something, including myself. I always learn something new. So we certainly want to have time for everybody to have questions if they need to. So, all right. So why is an elder law attorney sitting here in front of you? God bless you, about special needs planning. Well, elder law is really special because not only is it an umbrella that addresses issues that are over, for folks that are over the age of 65, but also we handle issues that also affect folks living with disabilities who are under the age of 65. So we kind of run the gamut there. So everything from, basic estate planning to helping plan for people and loved ones, taking care of folks living with special needs, all the way through life's, care, lifespan planning. And so it's just a really special area to be in. So, okay, so anytime I approach this, it is always with dignity and respect for the people that we're caring for. So, and y'all as advocates and caregivers know that better than anyone else. I'm not exactly in the same situation, but I have a child with autism. He is very high functioning. He goes to Grissom. So I just want you to know that my heart is certainly with you guys. It is a beautiful journey, but I also understand the challenges somewhat that can be with having a special needs kiddo or individual that you're caring for. So let's just talk a little bit about, how can we help these kids and adults, through their lifespan? Because nobody, if you were not here, nobody is going to take as good care of that person as you can, because they're not you. We know that. But we want to make sure that, in the event that you're not here, what's the plan? Again, we want to make sure People know who is this person that you're taking care of? What is your loved one? What do they like? What do they not like? What does their diagnosis look like for them? When we talk about Parkinson's, for example, Parkinson's looks different for everybody. Down syndrome is going to look different for, different kids. They may physically look alike, but, everyone's different. So certainly approaching this with the heart of dignity and respect in the planning that we do. So I think the first thing that we need to talk about is, what does medical, quote, emancipation look like, right? So when kids are kids, you as the parent or the legal guardian, today what I'm going to do is say parent, but I certainly mean caretaker as well. Okay, so we're focusing today on children who are going to enter adulthood, but please know that this applies to, just blood does not make family. So just know that I'm going to use the word parent. Okay, so kids, this is specifically for Alabama, okay? So I'm not speaking to any other state. And please know today, also, I do have to say this since we're going to be on YouTube, that this does not constitute legal advice to any one individual, okay? So anyway, all right, Alabama. If you can believe it, the age of medical emancipation in Alabama is 14 right now. As a mother, that makes me want to throw myself straight out the window because I remember what I was like when I was 14, right? Maybe not the most responsible or able to make my own decisions, even though I thought that I could. So basically, any kid right now at the age of 14 needs, we're going to talk about them, but needs some medical powers of attorney. Okay. Now, we're going to go to January 1st of 2026. That age is going to go up to 16. Not great, but a little better, right? So just please keep that in mind if you have kids, grandkids who are going to be, their birthdays are coming up, that they really need these powers of attorney if they are, competent and able to sign those powers of attorney. When we talk about, a lot of people have questions about guardianship and conservatorship. Basically, guardianship is over healthcare decisions in Alabama. Conservatorship is over money other than something where you can be the payee of it. Okay. So you're not able to get guardianship proactively if that's necessary for you. The children in Alabama become legal adults for this case at 19. All right. So I'll have people coming in saying, hey, my kid's about to be 18. Well, it's great that you're here. I'm so glad you are. We can get ready, but we can't technically get guardianship for them until they're 19. So just be aware of that. And let's see here. So again, guardianship is a process where in this particular case, because I'm just going to assume for the purposes of this conversation that we have a lot of kids that are disabled since birth. And so what we would be talking about is what's called a custodial guardianship. A custodial guardianship. And that basically is an expedited process through the court system where, we're not having to give notice to that child or go through some of the legal requirements that would be required if we were trying to get guardianship over an adult. So it's definitely an expedited process. You would have medical documentation, which I know you certainly would in this particular case. Since birth, or maybe the child, God forbid, has suffered a traumatic brain injury, something like that. You're going to have documentation of those things. Those would be provided to the court. A guardian ad litem would take a look. That's a neutral attorney that is appointed by the court just to make sure everybody's rights are protected. And that guardian's going to say, okay, everything looks good. Let's go ahead and give that guardianship to mom, dad, or caregiver, whoever's the appropriate party. So there are ways, definitely. I know there's a lot of concern about what am I going to do as my child approaches, the age of majority here in Alabama. So guardianship is definitely one of those ways. Hold tight on the conservatorship. We're going to get there. So the other thing is to consider powers of attorney. Okay. So everybody in Alabama, or really I'm not going to say every state. There's going to be a version of this in every state, though, okay? Powers of attorney, you have a financial power of attorney, a healthcare power of attorney, a HIPAA release, HIPAA, HIPAA release, and an advance directive or living will. Those are your basic powers of attorney. So I'm going to go through those quickly, and then we'll talk about how they relate to your loved ones. So, of course, the financial power of attorney can be signed, which it says there's a whole laundry list of financial tasks that the power of attorney can do for you. Remember, this is different than if we go to the court and we say, hey, I want to get conservatorship, conservatorship versus a financial power of attorney. A power of attorney allows you to assist them. It does not mean that you can override a decision. Okay, so sometimes I know in different diagnoses, maybe it's easier for someone to take advantage of somebody else. They just go pull money out and give it to them. Kind of thing. So with a power of attorney, you would be able to go and assist them with their financial accounts, but you couldn't stop them from doing whatever they felt like they wanted or needed to do. So the financial power of attorney is also important because we have language in there now that is super important for long-term care planning. So if someone is or becomes disabled and needs benefits, it allows us to create trust for their benefit during their lifetime so that we can maybe move a little money around and make sure that they're taken care of. So again, we'll talk more about that.
Hey,
But the
Emily.
financial, oh,
Oh,
yes, go
sorry.
ahead. No, you're
There was
fine.
a question for clarification in the chat. It says this applies to children 19 years and up. Yes.
So powers of attorney, great question. Powers of attorney, yes, you become a legal adult at 19. So I would say 19, getting them ready about 18 to kind of, go down that path, but 19 is when everything becomes legally binding. All right. And I do always, when it comes to ages and numbers, I always give pause. I want to make sure I'm telling you the right number. So if I hear something different, I will definitely let you know. But my understanding is it's going to be 19 on that for Alabama. So great question. Okay, so our financial power of attorney is a great option. Again, they don't have to necessarily have the understanding of what is a stock, what is a bond, what is the process of selling real estate. If somebody is able to communicate and say, hey, this is my person. This is the person who cares for me. I understand, who they are, what their name is, what's their relationship to me, and that I want them to take care of my finances. That's pretty sufficient to being able to execute a financial power of attorney in Alabama. So if someone's able to, we're going to have notaries, potentially two witnesses there at the signing. So as long as we can see them making those marks, a notary can say, hey, this is the person that signed this document. So again, in the interest of dignity and respect, if we can, maybe start with those powers of attorney instead of going straight to the guardianship or conservatorship route. That's a great place to start. In terms of the healthcare, I know I talked about 3 there for just a minute. The basic healthcare power of attorney is different than a living will, okay? Sometimes you're going to see them in one document, maybe you'll see them in 2. But a healthcare power of attorney is more for a situation where death is not necessarily imminent. So some sort of incapacity or disability where you're not able to really communicate with the doctors or caregivers, and someone needs to make medical decisions for you. In the case of Alzheimer's would be a good example of this, advanced Alzheimer's, where, or you're in surgery, excuse me. The other example would be maybe you're in surgery. So the advance directive is different because that document is specifically comes into play in 3 different scenarios: terminal injury, terminal illness, and permanent unconsciousness. So you can kind of see the difference that, well, my healthcare power of attorney is if it's not those three situations. So we pray we're never going to have to even use that advance directive. But the advanced directive is where it's like, okay, death is imminent. Do I want to have food and water through a tube or IV? Would I want you to hook me up to machines for life-sustaining treatment? Those are the questions that we would ask in that document. And then, of course, what kind of bridges that together is our HIPAA language. So, under HIPAA, we all go to the doctor and they all say, do you understand your rights under HIPAA? And the type is about this big. And do we all read it? Probably not. But it basically says that your business is your business. So God bless you guys. If you called up my doctor and said, whoop, what's Emily's weight today? They would say, well, that's none of your business. You're not on her HIPAA release. And God bless you. I wouldn't want to scar you anyway. Oh my goodness. So, it's everybody when they become an adult, that's just the way of saying they're their own independent person. So even if you're married to somebody, what the doctor allows you to do between you and your loved ones, that's between you and the doctor. What I'm telling you is what makes it legally binding to make those decisions, possible, and for the doctor or medical professional to have that dialogue for you or with you. So that's our basic powers of attorney. Again, when we're talking about disabled kiddos, we're not going to worry about a financial power of attorney, but we are going to worry about having at least the healthcare power of attorney and the HIPAA release. Okay, that's important. Now, an advanced directive might be a little too adult, you may not want to go there. I didn't do that with my son when he turned 14. But I tell you, I had him in my office when he was 14. So we definitely got that done for him as well. So before I go on, does anybody have questions specific to powers of attorney? Yeah,
Can you
go
hear
ahead.
me? Um, okay, so is it possible to have, like, my daughter has autism and I
Mhm.
would be the power of attorney and my husband, but if something happened to us, would we have another power of attorney after us to write that
Oh,
in
that's
there?
a great question. So, and I'm glad that you said that. So, normally, what we do when we have kids that have, disabilities is that we can put, if you have two caregivers, you could put mom and or dad so that either one can act. And then you can, if you have another trusted person, you could put that person as, number three, that if the two of you aren't there, we could
Yeah.
list 100 people. Okay. But remember that anytime, this is for you guys as well, anytime you have more than one person on a power of attorney at a time, what if the two of you don't agree? So that's more for competent adults to kind of just remember that. But in this
Okay.
case, yeah, so I would Bob and Sue and Claire, and you know what I mean? But I think it's totally fine to
Yeah.
have, if you have got two caregivers, put them both on there.
I just wanted to put my son down there if we decide to do this. I didn't know
Sure.
if it's my daughter's 22. I don't have anything yet.
Yeah. No, no,
So,
no. I think that's great. Anybody that, and then remember too that even though you might be helping them prepare the documents, if it's someone, you want to make sure it's somebody that, they feel comfortable with. So sure, because they are giving the power. So perfect question. Thank you for that.
Emily, there is another question in the chat from Jared. He says, because there's a comment about Kendra said that she was glad that to hear the age is going up, and Jared said the age is going up. What is the age going up to? And that's
Mhm.
16,
So,
correct?
so it's 14 now, and it'll be 16 as of January 1st. Great question. Okay. So we've talked about powers of attorney. You're welcome, Jared. We've talked about powers of attorney and we've talked about guardianship. So very quickly, let's touch on conservatorship so that we can hustle over to trusts and able accounts.
Oh,
So conservatorships.
hey,
Oh, did
Emily.
someone? Yes, ma'am.
Yeah, Kendra's what did you have a question, Kendra? Okay.
Yeah, really quick, really quick. Thank you, Miss Young. I just wanted to ask, in the case where there's two biological parents, but one they're separated or divorced, and one parent is the primary custodian, and let's say the primary custodial parent passes away, but the primary custodian assigned a second power of attorney who was not the other biological parent. How would that look legally as far as if they designated someone else who was not the other biological parent?
Gotcha. Okay. So power of attorney, again, is going to be different than a court proceeding. So I, as a, competent, we could all argue about that, but me as a competent adult, right? I went ahead and put like my husband as my primary and then my mother as the backup. I made that choice. So the power of attorney is a little different because it's me as an individual deciding who's going to care for me in advance. And so if your child is able, this is only going to be appropriate for a child who's able to say, I want mom and dad to take care of me, or these are who's been taking care of me. You know what I mean? So if you're working together with that child and they're able to say, I want 1, 2, 3, that power of attorney is going to be sufficient for that. But if there's a court order, I don't do family law. That court order is probably going to override whatever a power of attorney says. But again, I don't do family law.
Okay, thank you.
You're welcome. You're welcome. All right. So we covered basics of guardianship, that custodial guardianship, okay, and how that goes along with your healthcare powers of attorney, right? Guardianship means that you can overstep. We're parents, we're going to take the wheel here along with Jesus, as that song says, we're going to take the wheel. Um, and then also the powers of attorney, remember, you are their helper, but you can't override their decisions. But it's just kind of a middle step before we go, we know we're going to take control over them, so to speak. So just a moment to pause and say, if my child's able to do that, let's kind of keep it least restrictive as we can. So very quickly, conservatorship. Okay, so we have the custodial guardianship. Now we have the conservatorship. If your child is receiving benefits where you could become the payee, then, and that's all the assets that they have, you're not going to have to worry about this, okay? Conservatorship would be more for something like they've gotten an inheritance and they have money that needs to be managed. And again, I say that, I always say the asterisk because there's other ways to handle that money. But I'm thinking if they have assets that are maybe passed down from somebody, or maybe they are working and need some help. Again, there's a lot of kind of caveats to this. I want to be careful. I'm not saying this is the only way to manage it, but conservatorship would be over money that needs to be managed, income and assets. Where if you're able to be the payee over something, does that make sense? You can kind of do that outside of the court system, because you're going to have to do things like get a bond and do an accounting to the court. So anything, as much as I love the judges, I'm sure they're listening. As much as I love the judges, I want to keep you guys, out of the court system as much as we can. So anyway, so that that there is kind of a step here before we get to court. So we've talked about, the powers of attorney, then the guardianship, conservatorship route. And then, so that's definitely what we want to think about for life care planning. But now let's kind of focus more on the money part. And we're going to talk about, oh, hold on a second. It's a parent. Let's see. What do you got there, Jenny, for Amy?
She says, before you move away from guardianship, how does a parent having guardianship affect them as a paid caregiver on a waiver?
That is a question I don't know the answer to. Do you think that's a question you could, I mean, I guess, how is it being paid for? Or you know what, maybe that's something that we need to visit at the end. Why don't we do that?
Okay. Yep.
Yeah,
Is that
let's do
okay,
that.
Amy? I think Amy's good with that.
Okay, cool. Yeah, just to hold that one. Definitely hold that one. Okay, so now let's kind of go into the money portion for, I'm trying to think of the best way to start this. Let's go with lifetime. Okay, so you know that you have a child that is disabled and you say, okay, if I'm not here, I need to be able to provide for that child financially. Okay, so there's a couple of different tools that are used, um, The most common one that we're thinking of is that if you're not here, we're probably going to be looking at what's called a special needs trust, now more commonly called a supplemental needs trust. And I like the supplemental needs trust option because not only is it a little more, it gives a little more kind of dignity, I think, to the name, but also because it's a better descriptor. Okay. So people sometimes will say, okay, well, I want to leave my child Marcy. I want to leave her money, but I know she can't manage it on her own. So I'll just leave it to her brother and he'll take care of it. The problem with that is I know Marcy's brother may love her very much, but what if Marcy's brother is in terrible debt or has a drug or alcohol issue, something like that? Once you leave that money to a person, it is theirs. Okay. He has no legal obligation to have to give it to Marcy. Okay. And so disinheriting Marcy, there's a better way we can do that. Okay. And one way of doing that is through what's called a third party supplemental needs trust. Okay. There's two basic kinds. First party, I'm number one. First party is done with my money. So if I receive an inheritance, if I'm a disabled child and I receive an inheritance outright, it's potentially going to kick me off some government benefits, right? Some benefits that are income or asset based that I may need, to survive day to day. And so again, we're not trying to get around taxes or the government or anything, but this is legitimate life, day to day kind of living expenses. There are certain things that the money can and cannot be used for, but I'm going to have to put that into a trust that is established with my own money. Let's see here. And it's used during my lifetime for me. Now, when we talk about if it's established with my money, it is when I pass away, Medicaid gets the first crack at the money. Okay. So first party is my money going in. Third party is your money going in. Okay. So a third party is another person putting money into a trust for that other person's benefit. So I hope that makes sense. I know it's kind of jumping around, but first party and third party. So I'm going to be focusing right now on that third party. Remember, I'm mom or dad, I'm putting money in. I'm a third party putting money into that trust for a child. It can be done basically two different ways. One is that you can establish the trust now. You can start throwing money in it, in anticipation of the time that you're not going to be here. Or you can, through your estate plan, more typically through a trust, a revocable living trust option, but you can create a third-party trust, supplemental needs trust, that's going to come into effect upon your death. Okay, so either we can create it now. And for example, if grandma or grandpa want to throw some money at Marcy, they're like, oh my goodness, we really want to take care of Marcy. We know she's going to have a lot of needs. Then that for third party trust can be the beneficiary of Marcy's inheritance. All right. So again, third party trust is receiving that money in. Now, again, Marcy doesn't have a trust. Okay. She gets that money directly from grandma and grandpa. We're going to have to do that first party trust because now the money's come to her. All right. So with both kinds of trusts, the point is that it's not in Marcy's name. Okay. So we're going to have a trustee that's different from Marcy because we want to say that it's not, Marcy can't say it's my money and give it to me for X, Y, and Z. She doesn't have a right to demand any money. The trustee has the discretion. Okay. So let's talk for a minute about what does that discretion look like? What kind of things in this particular type of trust can the money be used for? Okay. So basically, the idea is to supplement, right? Remember, supplemental needs trust. We're going to supplement whatever that the state of Alabama or the federal government is not providing a benefit for. So medical needs, for example, your basic needs hopefully are going to be taken care of. Medicare, Medicaid, that's your doctor and hospital, right? Maybe your prescriptions. But what about dental care? You know, certain dental care may not be covered. Psychological, psychiatric support services, attendance support services, um, other needs, other care for which public benefit assistance programs may not provide. It can include additionally occupational therapy, physical therapy, speech therapy, not covered by benefits. Again, we're supplementing. Okay, medical and dental expenses, annual independent checkups, equipment, training programs, supplemental dietary needs, etc. Okay, so again, we're supplementing whatever those benefits don't provide. Now, here's kind of the kicker, okay? Remember that a lot of times that government benefits are going to pay for things like food. You might be getting food stamps, something like that. It might be paying for a place, money provided for residents, okay? So the trustee can distribute for things like residential expenses that are beyond basic rent costs, okay? So this could be furnishings, utilities, other than gas, electricity, garbage collection, or water, a telephone, internet, and television service. Okay, so hopefully we're kind of seeing the difference there, what government is going to provide for Marcy versus what your money can use to supplement it. The last category is going to be those social and vocational needs. Okay. This is where, you know, sometimes trustees can get a little bit in trouble. You got to be careful. But, you know, things like tablets, radios, I know radio, maybe not as much today, but, you know, having things that can enhance a person's life, help them be, you know, experiences like going to a baseball game, you know, helping them lead as, I hate the word normal, but as comfortable a life for their situation that they can. Okay. So certain vocational and educational training programs can be included in those supplemental benefits. I would be happy, just if anyone would like a list of what that looks like, a full list, I'm happy to provide that to you to give you some ideas. Um, but I hope that makes sense that again, anything that is in this type of trust, a special needs trust, can only be spent on those type to supplement, not replace. Okay. God bless you guys. I know I said that like 5 times, but I'm just trying to, you know, get it in there. So those are the types of things that a supplemental trust can provide for. So, the other part, remember, we're going to go now we talked about first and third. Let's head back to first party for a minute, okay? The rules are going to be the same for what the money can be used for, all right? But perhaps that money's in what's called a pooled trust. So I don't know if you guys have heard of the Alabama Family Trust would be an example of this. So you can have a first party trust that's established by the person who got the money with their money, or a pooled trust is a type of first party trust. Okay. It is established and managed by a nonprofit association. Okay, so all the money from everybody goes into one pool, kind of like an attorney's trust account. You can put all of the client money into one big pool, but everyone has an account with that nonprofit. There is a Medicaid payback provision, Alabama Medicaid, again, on any first party trust. Medicaid is going to get paid back first. All right. And again, the trustee, Alabama Family Trust, would have the discretion whether or not to provide a distribution for that beneficiary's benefit. Now, again, we can't be giving everybody a lot of cash, because then that means that they're having control over what's called the corpus of the trust, the principal, there of the trust. So we just have to be very, careful about that. But I'm trying to be as concise as I can, but this is one thing to talk about that's so dependent on everybody's different situation about what makes sense for them. So I'm just kind of trying to explain them as best that I can in kind of a general sense. So again, we have trust that can be created with the person's money, that's with their money. We have third-party trust that can be created with money for other people. And those, people, I see a lot of times, I've seen them done both ways. If you're going to give money to your child, you can certainly do that upon death or during lifetime. Okay, so you just would need to talk to your estate planner about that. Okay, any questions about trust? God bless you. I'm sure you have 100 of them after the description I just gave you. But before we go on to ABLE accounts. Okay, the silence says, oh my goodness, we are all adequately overwhelmed, and we
Yes.
can keep moving around, keep moving on. Okay, so ABLE accounts. I'm seeing that we're at about 1040 almost, so I'm just going to touch on these pretty quickly, and then we'll go to the question and answer portion. But ABLE accounts allow a disabled beneficiary some personal autonomy over their finances without losing government benefits. All right. It allows for some checks and balances on their spending ability, but they still are able, to have some ability to use the money somewhat as they see fit. Everybody, is entitled to one. Okay, they only get one. And they, in order to establish one, must have been disabled as defined by Social Security before the age of 26. All right. As of today's number, it's 26. Big things coming in 2026 because it's going to change to 46 on January the
Oh.
1st of this year. Yeah. So we're
Oh,
excited about that. We're going to be able to use this great option for many more people. So 26 now, 46 on January the 1st. Okay.
wow. Oh,
So I know it's exciting. I know I'm excited.
wow.
So, okay. So the maximum limit in Alabama is $475,000. That's the max limit that they can hold in it as of today at any time. Okay. The first $100,000 of that does not affect benefits. Okay. So if they've got $100,000 or less, they're not going to be looking, government's not going to be coming in saying, hey, income, or excuse me, not income, asset limits, any of that stuff. So we're keeping that under the first $100,000. And then if you are going to gift them money, contributions as of today cannot exceed $19,000. That's per person, per donee. So if you're a married couple, you can each give $19,000, okay, to your disabled loved one. Also, SSI and SSDI can be deposited up to the $19,000 limit. So basically, that number is always going to match your gift tax limit. Now, when we talk about gift taxing, I always like to tell everybody, just because you give someone, if the limit is $19,000 and you give someone 20, all that means is that you just have to tell the federal government that you gave that extra $1,000. Okay. It just means it's not reportable until that time. And then there's this whole federal, you don't even have to worry about it. It's insane right now how much before you would have to, necessarily pay taxes or anybody. But the point of me saying that is it just means you have to report it, not necessarily pay on it. Okay. So employed ABLE beneficiaries can contribute an additional $15,060, so 15060, or the total of their wages, whichever is less, in addition to the standard $19,000 limit. Okay. So ABLE assets can be spent more readily and easily on a wider variety of things without any impact on SSI. Okay, because your SSI usually means automatic Medicaid benefits in most states, right? Let's see, what's Jared got there, Jenny?
Jared's asking, is TBI any age, or does it fall under the 46-year-old rule as well?
Great question. So are we talking about traumatic brain injury, correct?
Yes.
So a disability as defined by Social Security, currently that happened before the age of 26, but as of January the 1st, that happened before the age of 46. Okay, so as long as the disability happened prior to that age, then yes, they will qualify for an ABLE account. Okay. ABLE accounts do have that Medicaid payback provision because we're talking about number one, first party money. Okay. So as an estate planner planning for special needs, I get a little nervous about having a crazy amount of money in that ABLE account. I would be thinking more of, well, maybe we should put it in that third party special needs trust, because third party special needs trust, your money Medicaid does not get a crack at that as a payback provision upon the death of the beneficiary, if that makes sense. But quickly going back to the ABLE account, I don't know if anyone here has used a TrueLink card, but it kind of acts like a debit card. And so your loved one can use that. All right. Jared, what you got?
All right, we're doing double duty in here. You froze up right when you was answering a thing about TBI. So we heard the very end.
Oh, I'm sorry. Okay. No, you're fine. You're fine. I had just been making sure that I understood. We are talking about TBI, traumatic brain injury. That sounds like that was correct. So basically, if the disability, as defined by Social Security, happened prior to age 26, did it do it again?
A little bit. So
Okay. Oh, I've got
I
an
wrote
idea. Hold on. Let me put it in the chat box. Hold on. If a disability that happened prior to age 26-46, then ABLE. Okay. Okay. Hopefully that got it. Good deal. Okay, let's see. TrueLink card. Okay, so an ABLE account is a little different about what they can use the money for. Remember, it's a little more expansive. So supplemental needs for a supplemental trust. Okay, let's see here. Okay, so an ABLE account, remember you can put your money in there, right? I've made the money. I'm the disabled individual. I can put my money in there. An ABLE account can be used for basic living expenses such as food, heating fuel, gas, electricity, water, sewage, and garbage. Let's see here, wheelchairs, walker, hospital beds, other durable medical equipment, housing, including mortgage and property insurance, real property taxes and rent, education and training, such as textbooks and tuition, tools of the trade for their employment or vocation, certification and licensing fees. Those are things that are going to definitely apply to my son. Job coaching, work-related uniforms, etc. Transportation, so cars, buses, planes, trains, and automobiles, everybody. Financial management and legal fees, so things like tax preparation, financial advisors. Those dang attorneys got in there into the law and said, hey, our fees as well. So we got those. Attorney fees and court fees can certainly be paid from an ABLE account. Let's see here, assisted technology, love that. Computer, hearing aids, screen readers, eye devices, communication devices, and then also, sorry for the left turn here, but burial fees and expenses. So pre-planning fees for burial, funeral and burial expenses, and prepaid cemetery plots, and a partridge in a pear tree. So, gosh bless y'all, that is a lot of information, but that's just a very basic overview of ABLE accounts in Alabama. Whew, hopefully I didn't freeze up too bad. Jenny, are y'all there?
Yep, we're here. I was just
Okay.
looking for the chat. I don't see any questions coming in, so we're good.
Okay. All righty. So what I guess I want to encourage everybody to do is, in order to take care of other people, you have to take care of yourself. So all of the stuff that we're talking about today, I want you to know this is not a sales pitch from me. I want you to go to an attorney. Even if you have created your own documents, which usually that sets every attorney's hair on fire, but you know, I'd rather you have something rather than nothing. I just can't guarantee it's going to work, or, you know, it may cause a lot more problems than you think it's solving. But even if you've created your own documents, let an attorney just go look at them and spend an hour of time. Just make sure it really does work and that it fits your needs. But remember that if you too are an individual adult, so you need powers of attorney. You need one for finances and those 3 healthcare documents we talked about, because God bless you, what if you go and you get hit by the donut truck? We got to make sure that we have somebody, you know, to make decisions for you, because you can't help anybody if you're not able to take care of yourself as well. So we want to make sure. Oh, that was cute. It says not the donut truck.
Yeah.
Get a snack. At least have them give you a snack, you know. But yeah, so please make sure that you have that in order. And then I would say 2 of the hardest things for my estate planning clients are, one is who's going to be the guardian of children. And number 2 is that advance directive, okay? Making the decisions about, well, if I'm in this situation, if I'm terminally ill, injured, or permanently unconscious, do I think I would want to be on life-sustaining treatment or food and water through a tube or IV? I know that's not fun to think about, and it's okay to not have those answers. Go just have the conversation. Sometimes just having the conversation kind of makes it less scary. Okay. And so that way too, an attorney in these kind of situations, you know, trust, you really do need somebody that has a good amount of experience, especially with supplemental needs trust. You know, when you do your research of who you're going to work with, there are so many lovely, wonderful, knowledgeable attorneys, but kind of try to focus on those that have a little more experience for disabled families with disabled individuals living with disabilities as well. So I was trying to think of what else, other advice I've got besides don't walk in dark alleys at night. And I got one joke. I've got the one joke. Okay, you ready? What's the difference in an estate planner and a leech? At least the leech lets go when you die. So that's my one. That's my one estate planner joke that I've got. So anyway, okay, does anyone else have anything before Jenny gets us
Yes.
offline?
There is a question, but I think that's an offline question. So I'll go ahead and close now. And then whoever wants to hang around and chit chat with Emily for a few moments, you're welcome to do so. But before you leave, if you choose to, please make sure you put your email address in the chat box so that I can send you your stipend for participating today. Emily, again, thank you so much for taking the time out of your day to share with us. I'm going to go ahead and pause the recording, and then I'll go ahead and answer or read this question in the chat box. Okay.
Okay, great. Thanks, guys.